your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. Welcome to another day. This is our miscellaneous cases docket, which means that certain court stuff I stuck in this playlist that's of judges that I don't normally talk about on this channel. So that's where the miscellaneous cases stuff comes up from. Just want to see something. Ah, yes, my camera is working. Hey, Linda, sweetie. Let me put. Oops. Yeah, I'm trying to make sure that everything is working now. I got kind of knocked my camera off the thing, but yeah, let's get started with our miscellaneous cases docket. Let's get started, and I'll be watching. I am watching. Let's see who's on here. I have two on my side. One was on Busted, but on Rumble. That's okay. Let's get started with.
Jerry W. Hicks versus Bates Chevrolet, 2501754. You two want to, whoever's here from Bates or wherever else, you guys want to talk? See if you, come on up to the podium, Mr. Hicks. You're limping. You want to have a seat at the table?
I'm sorry, Governor?
I said you were limping on your way up. If
I'm
you,
just old. I think I didn't know arthritis tonight.
no, I understand. I'm just asking if you want to have a seat at the table.
No, I'm good, thank
You
you.
sure? All right, tell me your name, sir,
Jerry Hicks, Your Honor.
and your name, ma'am.
Good morning, Your Honor. Diane Boring from Michael H. Chevrolet, General Manager, acting as agent.
50% of people in this country.
All right, I think you said Warren is your last name, correct?
Boring, B-O-R-I-N-G.
B-O-R-I-N-G.
Forever Joe.
Diane Boring.
Correct.
All right. And your two names,
Sherry Graff?
G-R-A-F-F,
Yes, sir.
S-H-E-R-R-Y.
Yes, sir.
Ma'am, your name?
Megan Morris?
M-E-G-A-N?
M-E-A-G-A-N?
M-E-A-G-A-N, Morris, M-O-R-R-I-S.
Correct.
All right, today is the date scheduled on a small claims matter. Before we go on, I need to advise you of your rights. You don't have to proceed in the small claims division. Mr. Hicks is sued for $4,000. You don't have to proceed in the small claims division, though, if you don't want to, defendant. So in other words, if you proceed in the small claims division, both of you are giving up certain rights. The company is giving up certain rights, as are you, Mr. Hicks. You're giving up the right, sir, to seek in excess of $7,000. You're giving up your right to have a jury trial in this case. You're giving up the right to hire a lawyer to represent you in this case. And you're giving up the right to appeal my decision in this case. That is the same for Bates. Do you understand those rights, Mr. Hicks?
I certainly do, Your Honor.
Do you understand those rights, Ms. Boring?
Yes, I do, Your Honor.
Do you wish to give up those rights, Mr. Hicks?
I do not, sir.
You want to have the case removed?
I do not, I'm sorry. I want to proceed with the case.
So you waive the rights that I just enunciated? Are you sure? Yes?
Yes.
I just want to know, she has to take down what you're saying.
Okay,
Do you waive those rights?
yes.
Ms. Boring, on behalf of Bates, do you waive those rights?
Yes, I do, Your Honor.
Are these two going to be witnesses?
Yes, they
I'd
are.
like you two to go right over there to the jury box. One of you can step in the jury box. That door pulls out and the other one can stand. Pull that door out there, please. And then one of you can go in there and the other one could stand outside. That is a microphone. So I want you to stand right by that microphone, Ms. Graff and Ms. Morris. I'm going to ask all of you to raise your right hands. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God. Mr. Hicks,
I do,
Ms.
Your Honor.
Boring,
I do, Your
Ms.
Honor.
Graff,
Yes, I do.
Ms. Morris.
I do.
I don't know what this means. It says defendant failed to repair the 2003 GMC Yukon. You listed the VIN number. Defendant also refused to release that vehicle to the plaintiff.
That's
Oh,
correct.
did you pay them $4,000
I did, Your Honor. I have a receipt that I did pay the $4,000
to perform what type of work?
to repair my vehicle.
Yeah, I know, but
Well, I didn't know exactly what was wrong with it. I took it to Bates Chevrolet on the 16th of December and dropped it off. And on the January the 7th, Megan called me and told me that the vehicle had serious internal problems and it would be cheaper or it would be like they could order a new refurbished engine and it would probably cost about the same as for them to go inside and try to figure out what was wrong with it.
okay. What did you tell them to do? That was January 7th of 25. Yes?
Yes, sir, Your
You
Honor.
took it in December 16th of 24, correct?
That's correct, Your Honor. On the, if the court allowed me, on the 15th, Megan advised me.
Megan? Ms. Morris?
Of course.
Okay.
She called and advised me that my vehicle would be ready in a couple of days. So I paid $4,000 for that receipt.
What did they do to the vehicle?
Pardon?
What kind of work did they perform?
They were supposed to rebuild the engine, put in a refurbished engine, put my engine back together.
Okay. Do you agree with everything you said? Did they agree to put in a refurbished engine for the price of $4,000?
No, sir, the cost of the refurbished engine was $8,000. So we got a name drop, the vehicle was dropped off. We're not able to diag it until the 16th of January. Once the vehicle was diagged, Megan did speak to the customer and explained that there's multiple problems with the vehicle and that we could try a refurbished engine. This vehicle has 251,186 miles on it, sir, and it is a 2003.
How many miles? 200 and,
251,186.
so she told him, is that right? Did you tell Mr. Hicks that you could try a refurbished engine?
So on the day that I had called, first and foremost, I talked to his son. It's his son's vehicle. I had talked to his son. I explained that we had to start here, that there could be, at the end of doing the internal issue that it had, there could be more wrong with the vehicle. Total was a little over $8,000. Through Michael Bates, you take down anything over $2,000, you have to have half down to order these parts, correct? So I did that. We take down a date of birth to authorize that because the customer obviously was not there at the time of the call over the phone. Then they put down the $4,000. We went ahead and did the internal work on the vehicle, and there was still issues that I had told them could very well possibly happen, and therefore it did.
And therefore what?
There it did. There was still more issues found after putting in the engine. There was not a couple of days. It takes almost 2 to 3 weeks just to get an engine.
You do not want to start a
So,
All right, so the refurbished engine was never put in, right?
we did put it in. We completed that work.
I'm sorry, when did you complete that work?
January 9th, Your Honor.
And the car's been sitting there since January 9th?
Yes, Your Honor, because there were more issues with the vehicle, which we had told Mr. Hicks. So we were gonna do further diagnosis after the engine repair. By the time my technician pulled it in to do the other diagnosis on the vehicle, Mr. Hicks had canceled his payment. So we would no longer work on the vehicle.
So you didn't receive anything then from
So
Mr.
he physically came into the dealership, did a $4,000 credit card transaction,
And then canceled it?
and then canceled it out from under us.
So you
Yes.
paid nothing?
No, sir, Your Honor, I have a receipt here. They still have my $40,000. I put in a dispute against Bates Chevrolet for $4,000. And Bates Chevrolet responded back to my banker that I got what I paid for. They still have my $4,000.
We did dispute it, we did win, sir. So we do have $4,000 in-house after the back and forth.
How much does he owe you?
He owes us $4,000 right now. The vehicle still has upper engine issues, not the engine itself. But again, Your Honor, you're talking a $251,000 oath.
Well, I know, but
Yeah.
you want to pay another $4,000 and it's still not going to be drivable?
It's not 100%. It is not 100%, but that was.
How much was
not
that
guaranteed.
vehicle worth?
I don't have a value.
Do you have any idea how much that vehicle was worth with
I
251,000?
paid, I'm sorry, I don't mean to cut you off. Go ahead, sir.
No, I just wondered if you have any idea what that vehicle
I
was.
paid $3,000 for it a few months later in Arkansas.
A few months later, when? I don't know what you mean by that. In 2003 or just now?
No, I bought the car in '24.
Okay, so a few months before this, you paid $3,000 in Arkansas.
Yes. And I have notes here, Your Honor.
Where'd you get this from, a private seller?
Yes. I have notes here, Your Honor, that every time I talk to someone from Misc Chevrolet or went there and visit, I make notes. This is what I'm testifying on today.
I want to hear from you. I want to hear from you.
Well, when she mentions they, there is no they. I'm the owner of that vehicle. So if somebody else has something to say about what to do with that vehicle, that's not my business. I'm the owner.
Okay.
Okay. My make continue, Your Honor. On the 3rd of March, I called, left a message for the young lady here to call me to discuss the matter. Well, she never called me back. I did hire an attorney, Blake Speck, out of
I don't want to know your conversations with your lawyer.
Okay. Well,
Okay, if he did something for you you think is relevant, feel free, but
I do, Your Honor. He wrote a letter. He also called, talked to Sherry and Megan and asked for paperwork in regards to this vehicle, that's what they've done. Neither one of them, responded to him at all.
all right, but we need
I
to,
have an attorney today.
no, I get it.
But when she called me and told me they had an electrical problem, I said, we didn't have an electrical problem before. Started, and about that too, Your Honor. I went to pick up a battery there one day. Megan said, he'll have the mechanic driving into the bay while I get the battery out of the back seat. Probably 10 minutes later, the mechanic comes in, and I have a date when this happened.
I don't want to hear this.
Oh,
It's okay, I'm gonna come back. But I want to know.
may I speak, Your Honor?
No, I want to ask a question first, and I'm not sure how I want to phrase it, except to say, it sounds to me like you initially promised, and I'm asking you if this is true or false.
Absolutely not, Your Honor.
I didn't even ask you the question.
Okay.
How do you know? You didn't say that once we refurbish the engine, or get me a refurbished engine, that this is going to operate adequately?
A vehicle with 251,000 that is not running, sir, we can't guarantee you anything. And the vehicle was for his son, and I think he was just trying to get his son back on the road. We don't want to take anybody's money.
I know, but if he paid $3,000,
The total cost, Your Honor, was $5,000 for that motor.
didn't you tell me you paid $3,000? No, I know $4,000, but didn't you tell me you paid $3,000 for the car in Arkansas in
Oh,
'24?
yes, Your Honor.
That's what I'm referring to.
Sorry, I
Yes.
apologize.
So we're up to so now he's spending another $8,000 and the car isn't still drivable? It's not ready to go? I mean, that's like, I don't know what that's like. I mean, that's bad business.
They still have my vehicle, Your Honor.
May I speak, Your Honor?
Yeah,
I completely understand your feelings. And
Well, I want-
initially, when I read this, I truly understand how you feel. However, if he's adamant about fixing a car for his son, all we can do is say, this could happen or this could happen, and ultimately, it's his decision. I would not invest that kind of money in a 251,000 mile car.
did you have the discussions with him or
No,
did
sir.
somebody else? Who had the discussions with him?
Megan,
What did you tell him?
I did, when I called him and told him what was going on with the vehicle. that
And
he-
he'd already paid $4,000 down.
I wouldn't have known what he paid to buy the vehicle, that's not. it's
No,
not-
no, no, yeah, wait, no, I'm not talking about what he paid to buy the vehicle. That was a different issue.
Okay,
He'd already given you guys $4,000.
but when I sold the job and told him what it needed, I told him it was $8,000. I have to have half down to order the parts. The
Right.
parts are a little over $4,000.
Right.
This is by any customer that comes into Bates.
Right, this is on the 16th, you had this phone
I had
conversation.
this conversation with this gentleman on
And
the
what did
phone.
you tell
Well, first I had the conversation with his son. We need to be open and honest. I told the son, because the son is who I initially had the telephone number in communication with, it is his vehicle. Whether it's in his dad's name or not, I don't know that. So I had the conversation, his son got extremely rude with me to the point to where I didn't feel comfortable any longer talking to him on the phone. At that point in time, he hung up on me. Mr. Hicks had now called. That was my line of communication. He apologized that his son was extremely rude to me and called me every name under the sun. And he asked, what is going on with the vehicle? I said, I had told your son that it came in for a check engine light and the vehicle wouldn't go over 10 miles per hour. It had internal engine failure. This is the cost for it. This is what you have to have down. This is where we need to start. Starting as it means we could put this engine in and you very well might have more issues with your vehicle. I do not know. But we need to get it up and running, at least with the engine in it, because that's what's showing that we have to do first. This gentleman had told me, absolutely, here's my birthday to authorize this job, which everybody has to give a birthday if you're not there in person to sign or to give, we take authorization over the phone with a birthday. I've got his son's birthday and his birthday. He agreed to the $8,000. Came and gave me $4,000 down. We put the engine in it, test drove it, still has issues. I called him, let him know that, and now here we are.
Jeez.
I didn't
Is what
personally
she
do
said-
anything or promise anything.
Is what she said just true?
It's not, Your Honor. She has never mentioned $8,000. I think, Sherry, I talked to her one day, and she told me there was no compression in number 1 and number 7 cylinder, and that my engine had a warranty. I said, well, you bought the engine. You get a new engine in here. $8,000, I think Sherry mentioned $8,000, and I said, what are you talking about, $8,000? The price of the motor. What did you come up with $8,000?
Wait a minute, slow down. So you're disputing her testimony that she.
Absolutely, that's
What, you gotta let me finish. You're disputing her testimony that she said cost $8,000 and we need half down or $4,000. You're disputing that?
I certainly am, Your Honor.
So what did she tell you when you gave her the $4,000 before you gave her?
I didn't talk to her.
Let me finish. Let me finish.
I'm sorry.
What did she tell you, or Sherry, or whoever you want to tell me, what was conveyed to you as to what would happen once you gave the $4,000 payment to them?
Okay, Your
Did
Honor.
they tell you $5,000 and you got a new engine?
No, Your Honor, at the very beginning, Megan told me that the engine, refurbished engine would cost $5,000. On whatever date I just mentioned, she told me the car would be ready in a couple of days. So I went into the cashier, got my credit card, paid $4,000 down, knowing I still owed $1,000 because I had $1,000 in the bank.
Did you have 1,000 what?
That I had $1,000 in the bank. I
Okay.
paid them for it, total price was $5,000. But after I made.
Tell them it was 5?
No. I told him I need half done what the total was. The total was a little over $8,000. He came in and paid half of it, which was $4,000 even. I don't know where any of these extra numbers are coming from.
Go
Not
ahead.
a clue.
Your Honor, anybody with common sense knows that a refurbished engine does not cost $8,000.
Well,
Everybody knows that.
well, I gotta tell you, I'm not savvy with vehicles. You can say that. I don't know that I would know what a refurbished
I am,
engine
Your Honor,
costs.
I used to own a junkyard too.
Well, you know dealerships charge more anyways, right?
They don't charge you $4,000, more than what the motor's worth. She gave me a price of $5,000. I never heard $8,000 till I went in and seen Sherry about where my vehicle was. She said, well, we're afraid you're gonna steal the vehicle. So we
Steal the vehicle?
Yeah, they thought I was gonna steal the vehicle.
How are you gonna steal, how would he steal the vehicle?
No, Your Honor, what I said is, he had disputed the charge at that time, the 4,000, and we had put in a disputal for that, and he wanted to pick up his vehicle, and I couldn't release the vehicle without payment. Where he put $8,000 into the vehicle,
Right.
so,
That's
We
not
did it.
true, Your Honor.
and if I may, can I speak?
Sure.
Not only did we do an engine, we did, oil cooler lines, we did other repairs as well. I don't have the paperwork in front of me, but we did other things that led up to the $8,000 that he
The
approved.
equivalent though, I wanna tell you,
This is how you can uncover all the secrets of your family.
paying $10,000 for a car and then going out and paying about $25,000, $26,000 in repairs to get the car working, it just doesn't make any sense to me that somebody would buy a car for $3,000 that I can't believe would Blue Book for $11,000. And now he's got himself in a position, or at least a situation's created, where he's got to pay $8,000 more and it still doesn't have a drivable car. That's what you're telling me, right? There's other issues to deal with?
He does have other issues, Your Honor, but he also had it at 2 other repair shops before it was at ours.
Is that true?
Sorry, Your Honor.
Did you have the vehicle at 2 other repair shops before? Let me finish.
Sorry.
You gotta stop doing that. See, I don't want to sound rude either, but she's got to take down what is being said here, okay? Everything's being recorded.
Yes, Your Honor.
Did you take the vehicle to 2 other repair shops before you took it to Bates?
I took it to Auto Dock, down the street. That was not the problem. I took that there.
Wait a minute. What do you mean?
I was having other little issues, electrical issues, the radio. And anyway, I took it to George's, which is on the other side of West Road. I left it there for a week in this parking lot. He never touched it. So I was able to drive it down to Bates Chevrolet and left it in their parking lot and talked to the mechanic or the associate in there. He said it'd be about a week before we get to it.
When the mechanics performed this work, did anybody go out and attempt to drive it?
After the repair was made.
Yeah,
Yes, sir.
and they still said what kind of problems
And that's
exist?
when he had a 3-cylinder misfires on top of the engine. Yes.
Well, this is a mess. So he's giving you 4, you want 4 more, and he still doesn't have a car that's operable, and he paid $3,000 in 24 for a car with 251,000 miles.
And it was his decision to put that money into that vehicle, sir.
Well, but you're the experts, aren't you?
Well, we.
I mean, that's a little like saying to your doctor, hey, I want you to do this, and the doctor knows it's, or lawyer, whatever it is. You guys are the experts. Couldn't you tell by running all these diagnostics as Ms. Boring was talking about as to what exactly was wrong with the vehicle? So you could say, this is the problem, this is the problem, and that's the problem, and that's going to cost X amount of dollars. It seems pretty simple to me. Maybe I'm making it too simplistic, but doesn't it seem like that's the way it should have gone about?
It's really not that simple, Your Honor. So we did have to get the vehicle running with an engine. It had 251,000 miles. We did advise him that there may be other issues. He had electrical issues. He had it 4 down the road. He still has electrical issues. I mean, there's a lot of problems with the vehicle, but he did authorize the repair for the engine.
Mr. Hicks?
Your Honor, Megan told me that my vehicle would be ready in a few days. All it had to be, is her words, just buttoned up. That was her words.
All that way?
That all it needed to be was buttoned up. That's what her words
Do you have any estimates, written estimates for him? Did you give him any written estimates? I'd like to see those.
Yeah, I would too.
Did anybody say on there, hey, no guarantees, might need further work? I want to see the documentation.
Yes,
I mean, you guys are the experts here. It seems to me that on estimates, you would have noted there still may be further issues to deal with, even if we put in a refurbished vehicle. That's the way I'd see it right now. Let me see what you got. Do you have any notations like that on any of this paperwork?
All I have here, I do have a written estimate on here. Well, it's the total for the estimate. You'll see a couple on here.
Tell me what the total for the estimate was. Read it to me. Just you can read it right there. Read it.
8,500 for the engine, intake manifold, exhaust bolts, the gaskets, the engine mounts, the coolant hoses, and then we also did a power steering pump, engine and bolts, necessary bolts and fluids.
Did anybody say there still may be other work that needs to be done?
When Megan spoke to him on the phone, this is our starting point. We always say that because especially when we don't have a car that
You should
is.
put it in writing. Did you say that to him?
I did, 100% I did. I said, sir, this is where we are right now with it. We have to start. My keyword is start with an engine. There very well could be more issues with the vehicle, but we have to start here. Here's the total. This is what I need down, and I need your authorization to do so. Well, how do I get that? Who's your birthday? I have his birthday on here written, circled, and I even have the total.
Was all that work performed
Yes,
that you just wrote, that you just read to me?
Yes.
And you say they didn't tell you that?
No, sir, Your Honor, they did not. Now, I always say, you know, it's easy to remember the truth, but it's hard to remember a lie, so, you know, somebody's not telling the truth here, and it's not me. I mean, I'm telling the truth.
Did it have on the estimate, you said 8,500, right?
Yes, sir.
It is.
Was that before or after he made the payment?
That was before.
And did you ever give him any kind of receipt indicating that the balance was going to be 4,500 after he paid the 4,000?
No, I do have the receipt for the $4,000 down and his date of birth. Again, that's what we do when we get authorization if the person is not in front of me. We get a date of birth.
And that's figured out.
Yeah.
All this other stuff that's adding on here, this is the first I've heard of that. Power steering.
Well, but you did get an estimate for $8,500, right?
No, Your Honor, the price was 5,000 for a refurb.
Did he sign that estimate?
I do not have a signature, Your Honor.
When was that? What is that date?
This is dated 3/20, oh, I'm sorry, that's his birthday.
Are you ready to feel good about your
The only date I have on here is 12/16. That's the day we wrote up the vehicle.
We have the date of when he took the $4,000
Well,
out.
wait a minute. You didn't know 12/16, you said?
That's when I dropped it off.
That's what he dropped it.
I know, but I thought you didn't know until after the beginning and you called him on the 15th or 16th of January. Didn't we already cover that?
So 1/17 is the date I have.
Let
That's
me
what
see
he,
the document. Let me see the document.
The date of.
I'm sorry this is taking so long, everybody.
Well, Your Honor, I just want the truth to be told here, and it's not been told.
So what do you think you bargained for? See that, please.
I'm sorry, Your Honor?
What do you think you bargained for? An operable car after you gave him 4,000 and you owed him one more?
Your Honor, being a Bank Chevrolet, I thought, because they reputable dealer, I assume they still are. But when I took my vehicle in there and was told that it needed a refurbished engine, or they could go into the motor and take it all apart, and they said it'd be just as well, go ahead and buy a refurbished engine for $5,000. I said,
Megan told you that.
yes, sir, Your Honor, I swear she told me. So I said, well, go ahead, I'll have a new engine in my car. Then I get the call, it's gonna be buttoned up.
There's just scratches and notes here.
And all this other stuff. Yes, I did sign for it.
Labor 3,800, it looks like you're saying estimate, right? 8,500 by Jerry Hicks, date of birth, and you have his date of birth on here.
I also have his son's date of birth, because that's when I started talking to him, before it went south with that.
I did sign, Your Honor, to have the $5,000 motor put in. This other stuff, I have no idea what.
You signed what?
I'm sorry, Your Honor.
What'd you just say?
I did sign a paper. She had me sign a paper for the refurbished engine at $5,000.
Let me see it. Do you have a piece of paper that shows me that?
No, she has the paper.
Do you have that paper?
it's what's in front of you, Your Honor. He didn't sign it. He gave us his date of birth.
Well, maybe, I'll take it. I'll sign it.
Slow down, everybody, please. What is it? I mean, these are scratchy notes, my lord. What am I supposed to know here? I mean, you got $5,500 written in circles here. What does that mean?
So
Just those.
the $5,500 was just for the reman engine, and then he added on the power steering pump, the lower trans lines, the left engine mount, and necessary bolts and gaskets. And I do remember you authorizing that because you had argued with me that nobody, or you didn't argue, you just told me that no one else had found the leaks at the other place. And I said,
Do you think he owes you money now? You didn't counterclaim. You guys didn't file a counterclaim. So this car's just been sitting in the shop for all this time? What a mess.
Can I speak, Your Honor?
Yeah,
I have no idea where my car is. It's not in the shop. I don't know where my vehicle is. Someone mentioned, I don't know who mentioned it, but one of these, I don't think it's this young lady here, somebody mentioned that they could get a quick claim deed, a mechanic's lien on my car and take it.
is the car still at the shop?
Yes, Your Honor, and we have
If I went over there right now, I will see the car at the shop.
so we have a building next
True or
door to us.
false?
Yes, true,
Okay.
true.
I know how this should resolve. I'm just trying to think of how I'm gonna do it. Well, if you don't mind me saying, as an advice to you guys, somebody needs to keep better paperwork here. This looks like scratch notes that I would have used in third grade. I mean, I can't even read this. And you got numbers all over here, like $5,500 it says, and it looks like it says doing this. What does that mean? Who wrote that? 5,500,
Mine.
and somebody else wrote 114,000 miles, it looks like, right? Do you have an extra copy of this?
I'm reading it with you, yes.
What does that mean? 114,000. What does that mean? Miles, it says next
Oh,
to it.
that's probably what the reman engine came with on it.
That's what those miles are. The word absence is miles. That's what
Okay,
it came
what's it say, $5,500? What's that?
That's just for the aftermarket. That's just for the price of the motor. That's how much the motor cost alone. That's why I'm really confused when it's just the fourth. How is that when the part alone was over 5,000?
I had something, Your Honor.
Yeah,
Megan did tell me that there would be tax on the $5,000.
that's 300, right?
I don't know what it was. But she said it was $5,000, and then later on, we was talking about it, because, I mean, they're nice people, you know. And she
Oh, I
said,
get it.
There's gonna be tax on that $5,000. That's what I fit that.
Where does it say anything on any of these estimates? I'm gonna ask you to look at this and tell me where it says anything about $8,000.
Right up here, it says 8,500, okay, by Jerry Hicks. Date of birth?
Yeah, but I didn't say,
4/1/47.
nobody told me anything about 8,500. She told me that he owed another 4,000. There's a difference. He gave him 4, I can do math, 4,000 and 4,000 is 8. Why did somebody write 8,500 on here?
Because I did tell him that it was $8,000 plus the tax.
Well,
So
that,
it was-
I,
I mean,
what,
we always round up just in case of, there's additional parts at the end, always happens. But that circle that is right there with his date of birth, everything on that is exactly what was authorized.
well, you have his date of birth on there,
And I
right?
have his sons also.
I know, I see that.
May I say again, Your Honor?
Yeah,
My son has nothing to do with this. He's my son. As far as authorizing this or authorizing that,
what do you intend, let me stop you a second. What do you intend to do with this car? You're gonna just assert a mechanics lien? Is that what you guys are gonna do? And
Your Honor, our business reputation is worth more than anything. I do believe there's confusion because if the cost of the motor is over 5,000, we have to pay our technicians.
Well, I get it.
Feed their families, there's labor involved, and I don't know if he's forgetting or what. I was not.
I find it to be believable, and I think he's got enough common sense, and I believe he's got enough common sense to recognize that you don't buy a car for 3,000, put 8,000 more into it on the IFCOM, that it will drive appropriately, and if it won't, that it's gonna cost me more money. That makes absolutely no sense to me. So I can tell you, I think,
Your Honor, may I speak?
yeah,
Please don't forget that he did take it to 2 other chefs. And
He-
he was frustrated
he
with the other two shops.
Well, the first one he took it to was something about a radio, and the second place it sat there for a week, I thought he said, at George's, and they didn't do any work on it, and he wanted to get the car running. True or false? So I think,
There was part.
wait, I think, in fairness, as strange as this might sound, I know it should happen, I just am trying to figure out a way to do it because you didn't file a counterclaim, okay? And I don't want to spend all day on this, but I want to do the right thing. I think what I'd like you to do is you should file a counterclaim if you think he's got another $4,000. Jennifer, I want you to listen, please. If you think he owes you another $4,000, you should file a counterclaim. And then, I'd like you to bring in the mechanics. I'm shocked that they can't figure out in the beginning how much money it's going to take, at least in a ballpark. I find it incredible to believe, like I said, that he would pay an extra $8,000 or $8,500 on the IFCOM that this 251,000 mile car is going to won't operate without the potential of further work. You can't just say, I'm going to fix this and this is what it is, and then not say, well, we don't know if it, did anybody lead you to believe that this was going to require further work?
No, Your Honor, did not.
Yeah, I don't believe. Jennifer, I'm going to send them down. And I'm going to have Bates file a counterclaim. If you think he owes you $4,000 or $4,500, you can file a counterclaim. And then I think we need to hear from the mechanics.
I'll bring the mechanics.
Now, I'm no expert. I hope you're going to have some good questions for him, okay, Mr. Hicks?
Yes, may I say one? May I get the possession of my vehicle from this show?
I can't do that yet. I'll move this case for you, though, I promise you. I promise you.
Okay, thank you.
I will move this case quick. Jen, when can I do this? Can I do this, if you think you can get the auto mechanic, I could do it next Tuesday or Wednesday.
Perfect.
No,
What?
on the 23rd, you have, yeah, we could do it at the end of your landlord tenants next Monday.
Good.
Would that work?
Sure the mechanic's gonna be available?
I'll make them available.
We'll adjourn this to June the 23rd at,
11:30.
and you go down and prepare a counterclaim.
Got it.
Counterclaim. And then they're gonna serve it on you. I just want you to be aware. They think you owe them $4,000 or $4,500 or $44,000 plus tax, which I guess would be another $480. I want copies of that, and then I want you guys to but John's bringing down some copies, Jen, and I want to make sure those are given to me, okay?
Okay.
That's taken on.
Yeah, but we're not going to resolve it today, so
Okay,
make it
Would it
short.
be possible for you to have Bates Chevrolet bring papers that I signed for work to be done?
We have got to the point where
Yeah. Well, they're saying they don't have them. They just have this approval order that was done verbally, and that's why she took your date of birth. But yes, any and all documents in any way related to this transaction, you are to bring here if they are not here today. Okay? So bring all the documents related to this transaction. Bring them, the mechanic or mechanics that worked on this. And we'll do it next week at what time, John?
11:30 on the 23rd.
The next month.
My only
Okay.
question, Judge, is service. If
You
we could,
can accept service, right?
okay.
Yeah, you just accept service. Wait for them to fill out the counterclaim. Let's not make this any harder than we need to, and we'll go from there, okay?
I thought it was gonna be an easy case, but
Well, I don't think it's as easy as maybe as, that's all I can say. Thank you all. Thanks for your patience. Okay. Virginia Ann Swindle versus Tracy Lynn Linville. 2402676. I gotta tell you, this case has not been a pleasure. One shows up, then the other one doesn't, then the other one does, then the other one doesn't. I've never seen anything like this. Your name, ma'am?
Tracy Linville?
Your name, ma'am?
Virginia Ann Swindle.
Why weren't you here on May the 20th? You know how many times you guys have not shown up on this? It's ridiculous.
I thought once the motion was denied, it was over. I'm sorry.
You were show caused because you didn't show up for a creditor's exam. Is that not what happened on this, Jennifer?
It is, Your Honor.
Yeah,
And then I believe at the last date,
I gave her a judgment of $3137.50. I gave her that back on December 3rd. This has been going on since I was young, presumably. I mean, it's been going on a long time for a small claims case. We're fooling around with this almost a year later. What is going on? You have your documents that you can show her as to where you work and your tax returns and everything else that you're supposed to bring?
I have to show her my,
Yeah. She's got a judgment against you. You haven't been paying her, have you?
I don't want to give her my bank information.
Well, she's entitled to it.
That's his meeting.
Yeah. She has a judgment against you for $3,137.50. $313,750. I entered that December 3rd. You guys, I've never quite seen anything like this. You didn't appear for a creditor's exam on April 21, so I issued a show cause. And then you didn't show up, plaintiff, for the show cause on May 20 when she showed up late. And I rescheduled it for 10. You need to go get your documents. Where was the, I don't see the subpoena in here, Jen.
I'm sorry, Judge, we may have misprinting it. It was originally April 21st at 9:30.
You need to go get those documents today. I'm done with this case today.
I don't
Okay?
understand what documents you want.
We're gonna.
Judge, she indicated on the subpoena, she wanted her social security number, bank account information, and job employment.
This is what, well, then you're gonna end up in jail.
I give it to the court.
Listen. You're gonna end up in jail then.
This is a swindler.
Ma'am, don't call her names now. I gave you every opportunity to prove to me that you had insurance. That's past history. We're not even going back into that now. Jennifer, I don't know how long it's gonna take her. Ms. Linville's gonna wait here until, Ms. Swindle's gonna wait here until Ms. Linville goes and gets all the information on that show cause, and I expect you back today. Do you understand?
I have my account number. I don't know what else you want.
Jen, do you have your tax returns? What did she ask for specifically?
I didn't have it.
I don't have it here. What did she ask for?
Needs her, she filled out item 3 and said, needs her social security number, bank account information, job-employment.
Where do you work?
I work for a contract company, ISG. I have a W-2 for that.
Okay, you still work for them?
Yes.
Have you paid her a penny on this?
No.
Why?
I haven't even seen her.
You owe her money. And you need to pay her.
I can pay some money today.
How much can you pay today? Half?
I'm sorry?
Can you pay half?
No, I can pay like 300.
She can garnish your wages. That's what we're coming to now. You can't do this.
I thought I was bringing you the information, not.
I'm gonna, Ms. Ms. Swindle, give me an installment payment order.
Over the last 75 years, over
the order. Jen, I want you to, what else do you have? Did you bring any of the other documents?
I don't have any other documents. I have a bank account, a checking account, and
Did you bring all that information with you?
I have that information. Yes. That's what has $300 in.
All right, but you're gonna have to pay $300 today. But the point is that she's entitled to that information. So she can garnish your bank accounts, garnish your wages. I know you let this go too far. Why are you shaking your head?
Because it was dismissed 3 times and then denied.
You didn't show up on the actual hearing date.
Fourth one.
Look, but, I mean, you guys have alternated. I don't want anybody to misunderstand me. You guys have alternated not showing up, it seems like. But there were 2 or 3 times in a row, Ms. Linville, when you didn't show up. And you got nobody to blame but yourself. I'm trying to think how I want to do this. Jen, can we,
Yes, Judge.
I've got enough to do right now. I don't need to be sitting here conducting a creditor's exam. I'm gonna swear you in, okay? Ms. Swindle, do you know what's going on here?
Yes, I mean, just the fact that we can get some kind of results, like, you know, when I came last time, the people was all saying, okay, I'm just hoping it could get to that.
All right, raise your right hand. You solemnly swear affirm the testimony you will give in these proceedings will be the whole true self you got. I can't hear you.
Yes,
Okay, so you have your checking account information.
yes.
Where do you bank?
It's Michigan Educational Credit Union
Where's that located?
in Livonia.
Okay, do you have a check stub?
No.
Do you have your account number?
Yes.
Do you have a savings account?
No.
Nowhere?
No.
Do you have any other checking accounts?
No.
And you work, Ms., I hope you're listening to this, Ms. Swindle, because you're gonna have to follow up. Where do you work?
I work for ISG, which is a contract company.
And where are they located?
I believe they're in Farmington Hills, but I actually work right in David.
Where is the address that you work at?
I don't have the address on me. I could get it.
You don't, how long have you been working?
Well, I don't get paid by them. I
Do you go into an office?
to a laboratory
How long have you been working?
since November.
And you don't know what the address is?
I've never had to use it. I'm sorry. Oh, you know what? I do have the contract company, but I got my W-2.
Okay, so we'll make a copy of that for you, ma'am. Listen, I'm gonna set her up on an installment payment plan. You can ask her any other questions. Do you have any bonds, stocks,
No.
mutual funds? I can't hear you. Do you own any real estate?
No,
Do you own any other assets other than what's in your checking account?
just my broken car. That's it.
Well, you live at 1787, right, Churchill?
Parents' house.
Are they still alive?
No,
Do you own the house?
it's up in court right now.
What is
My
that?
brother and my sister and me.
All 3 of you own it.
Yes. I would love to do a payment plan.
Well, I don't mind doing that for you, but how much can you afford to pay per week?
125, 500 a month.
let me do this.
You're invited to join Phoenix Energy's
Ms. Swindle, do you still live on Terry Street?
Yes,
That's 14564, correct?
correct.
And again, the zip there is 48227, correct?
Yes.
You're gonna have to provide her, Jennifer, I'm gonna send them down. I'm gonna have you provide Ms. Swindle with copy of the W-2, any other documents that Ms. Linville came here with. I'm going to simply indicate defendant filed a oral motion for installment payments on today's date. And you have a check for $300?
No, but I can do like Zelle payment or something of that nature. I don't have checks.
I thought you said you had a checking account.
It's a checking account. But they
You
never
just
give me
use debit
checks.
cards and things like that?
Yeah.
How are you going to pay the 300?
I can do Zelle if she accepts Zelle. You have a bank account?
I have been. Yeah.
Where can you go to get the $300?
ATM.
Good. We got them right down in the hall. $300 today, and then I'm gonna let her pay $100 every week. You get paid weekly. You said you could pay $125.
Yes.
I'm gonna say 100, and I'm gonna start this beginning on June the 27th. Okay?
Yes.
So the staff's gonna make copies of everything down there. And they're gonna give you a copy of the the order for installment payments. Now, you can't garnish wages as long as she's making the payments. Okay? You could potentially garnish bank accounts. That's what the rule says. But if she's making the payments as agreed upon here, I don't see the reason. That's what I'm doing. You go down the hall, make copies of everything, give it to Ms. Swindle. Ms. Swindle, you wait for Ms. Linville to come back with the money, or you can use our ATM, but there's a fee. I don't know how much it is, all right? Good luck, thank you. Who do we have ready, Jen?
Judge, we got credit acceptance in Vince and First National and Kovacs.
We need First National and credit acceptance. I don't know.
There you go, Judge.
Credit acceptance versus Jamie M. Vince, 17I895GC.
Good morning, Your Honor. Sazan Barda, P65425 on behalf of Credit Acceptance Corporation.
Your name, ma'am?
Good morning, Your Honor. Jamie Vance.
All right, so you filed objections to the writ of garnishment. And you're talking about, did you read this, Mr. Barda?
I did not get it, and I did not read it. However, we did talk about that she was objecting to a tax garnishment.
She's saying after she purchased the vehicle, it began leaking oil, took it to the dealership, they have repaired, they returned it to me after stating they fixed it, began leaking oil again. I mean,
Yeah, I think we're dealing with a judgment that was entered on April 27th, 2017.
Yeah, there's nothing I can do, ma'am. Did you guys talk about another payment arrangement or not?
We did not. I did give her an amazing offer to resolve, and I understand she really doesn't want to pay another dollar towards this because she thinks that it's a little unconscionable. And to be honest, sometimes I think that these things are also super unfair, the contract that people enter into with Credit Acceptance Corporation. However, be that as it may, this judgment was entered in 2017 for $8,254, and it's accruing interest at 13%. So she hasn't even paid the original judgment balance. So there is no, I don't believe that the objection should be valid. However, I did give Ms. Vince an opportunity to resolve it for something much less than is owed. She's going to think about it and get back to our office. But for today's hearing, I don't believe there's anything other than denying the objection to garnishment.
Ma'am, anything?
No, Your Honor. Sorry to waste your time.
I feel bad for you. I don't like these high interest rates either. It's ridiculous, but there's nothing I can do about it.
Well, the fact that the car blew up on me is not fair to anybody, but what can I do
know,
about
but
it?
was she defaulted? Were you defaulted? You know.
No, I voluntarily surrendered it because it blew up. The engine blew up.
I know, but you showed up
oil.
in 2017, ma'am. That was 8 years ago. If you felt like that, you should have done something. You can't just ignore a summons and complaint and then come in here and try to raise some defense 8 years later. I'm sorry, I really am, but how much did you offer to get rid of it for, Mr. Barton?
The balance due and owing at this time is $6,950.15, and I offered 20%, $1,390 to get rid of it.
To pay $1,000?
Your Honor, they've already been garnishing my wages. They've already garnished my wages for 9 years. They've garnished my tax returns for 9 years. Like, I feel at what point is enough for a car that blew up on me? Like, I didn't know it was going to keep going this long when it was completely unfair to begin with, which he even told me I bought a car from a bad dealership, were his exact words.
Ma'am, I'm not, look, I don't know what to tell you. I don't agree with these interest rates. I've seen them at 27. It's ridiculous, but I don't have anything to do with that. You can't come in 8 years later and raise a defense. You should have raised this at the time that the summons and complaint were served. This is 2017. I can't sit up here like a king and make my own laws. I mean, I can't, as much as I'm repulsed by it, I can't sit here and just write my own laws. I just can't do it. So I'm going to find that the garnishee shall immediately release all withheld funds to the plaintiff attorney and that the objections are invalid. Listen, I'm going to strongly encourage you. How much did you say you're going to get rid of this? 1,300 and some?
$1,390 within 90 days.
Ma'am, don't be penny wise and pound foolish. I mean, if you still owe $4,000 some dollars, that's going to continue to accrue 13%. Just figure it out. 13% of $4,000 is $5,200 or $520 a year. That's the problem. Pardon?
Right, I got it. $1,300 will pay for bankruptcy then also, you know? I mean, it's six, one half dozen the other.
Hey, you do whatever you got to do. I'm not arguing with you. You do whatever you have to do. If you want to declare bankruptcy, feel free. It's not any skin off my neck. I'm just trying to tell you that you got yourself in a bad position here, and I feel badly for you, but there's not a thing I can do. I can't just start waving a wand over here and start making my own rules. I just can't do it. I just think if you can pay the 1,300, you should get done with it. But if you feel like declaring bankruptcy, feel free. It's nothing I can do. I have no choice but to find that the objections are invalid. I really am sorry. Good luck to you, ma'am.
Thank you, Your
Thank
Honor.
you, Your Honor.
Thanks,
Good night.
counsel. Kovacs.
Yes,
First National versus John A. Kovacs.
Yes, sir.
2400424. All right.
For the record, Your Honor, Albert Kim, P70301 on behalf of plaintiff in this matter.
Mr. Kovacs, your name?
John Kovacs.
All right. What is this, counsel? Let's see.
It's a motion to lift the bankruptcy stay. We had filed this case back last year in January, and right before we had our motion scheduled for summary disposition, defendant filed bankruptcy. His bankruptcy was dismissed as of May of this year, May 20th of this year. Sorry, these dates are all wrong. May 20th of this year. So we're trying to get everything kind of back up and running again. A defendant will likely be filing bankruptcy again. He was barred from filing bankruptcy for a period of 6 months since he's converting it to a 7. But my client is persisting that they want to reinstate, which is fine. I would just ask that we do reinstate based on the bankruptcy being dismissed, and we just schedule this out for our motion for summary disposition at some later date.
Can somebody, whose dog is that? Can somebody stop the dog from barking, please? Appreciate it.
I believe it's Mr. Kovacs' dog, Your Honor.
My apologies. Oops, sorry.
I mean, I don't have any choice but to reinstate the case. How much is owed on this, counsel?
Currently, Your Honor, there were 2 accounts the defendant had with us, and at the time we had filed suit, they had been filed separately. This one was $17,361.26 with costs.
So the Chapter 7 bankruptcy petition was dismissed, and then the defendant was precluded from filing until November. Is that accurate?
That is my understanding, Your Honor. So maybe as a go-between on this one, maybe we could reschedule or renotice our motion for sometime around that date. So if he does follow through, then we will.
You tell me what you want to do. You filed the motion, not me.
That's what I'm suggesting to the court, Your Honor, is that maybe we set this out for a date in November if the court is willing to do so, so we can hopefully get this done without any further appearances.
Why don't we do this? Jennifer, you're out there, right?
Yes, Your Honor.
I'm going to just say, plaintiff, listen, I don't want to have to adjourn a motion for 6 months. Plaintiff can refile motion to reinstate case with no filing fee, I'll say. And you're moving to dismiss this motion, correct, counsel?
Built for your casework, grounded in the record. That's
If the court's willing to do that, that's fine, Your Honor. If we don't have to repay the motion fee, I don't see any harm in that.
Plaintiff's motion to reinstate case dismissed. And you're good with that? You're making that motion, right?
Correct, Your Honor. I mean, again, I don't want to waste the court's time anymore. And in speaking with Mr. Kovacs, it's a foregone conclusion that he will be refiling once he is.
No, I know. I got it. Go ahead and that's what I'm going to do. I'm going to dismiss the motion to reinstate the case on plaintiff's motion. Then you can refile it if you choose to at the appropriate time in November or thereabouts. Okay. And if he does, Jennifer, make a note that I said he doesn't have to pay the motion fee.
Yes, Your Honor.
LVNV versus Laura Bryan, 2501009. Good morning.
Good morning, Your Honor.
Your name, ma'am?
Laura Bryan.
Counsel?
Good morning, Your Honor. Brad Johnson, P75416, on behalf of the plaintiff.
All right. Let's see this one. I didn't have a motion on this, did I? Oh, yes, here it is. Okay, I'm sorry. All right, so this is your motion to set aside default judgment, ma'am. You can go ahead and proceed. Tell me what you'd like to say.
Good morning, Your Honor. So pretty much my motion, let me pull it up here, or I'll sound like a rambling fool. So with what was going on, as I sent the timeline, pretty much I was served that I had an outstanding balance with LVNV funding. I did call to make some payment arrangements. I was told that the payment arrangements weren't suffice. They took all my financial monthly contributions and put them together, and it still wasn't enough. I did tell them that I would call back if I was able to, and I was greeted by a lot of unprofessionalism and was told that they seen everything in the system for my financial monthly, I would just say stresses. So I went over everything with the person in the office about
Ma'am,
what I
let me
pay
stop.
monthly
If
for
you owe
everything.
this debt, if you owe this,
And then
ma'am,
offered
listen
the
to me.
$80. She
Listen,
said she's seen it in the system. She would get back.
wait. We're not getting a very good connection. Do you owe this debt?
I do not know if I owe this debt, McNally.
Well, it's Judge McNally or,
I was given proof, with Your Honor, I'm sorry.
nothing. It's okay. Everybody calls me by my
I
last.
apologize. It's my internet connection. I promise I have walked all around this school from every classroom to classroom to find the best internet, and I cannot find it in this school. I'm so sorry.
That's okay. What school are you at?
I work at an early head start for Starfish Family Services.
All right, listen. What was the interest rate on this, council? Can you tell me?
Your Honor, it was above 30% this loan. I did speak with Miss Bryan in the breakout room, and I thought we had, I'm sorry, Your Honor.
30%?
Yeah, it's not a good loan. I'll give you that. But we did talk in the breakout room, and I think we came up with some type of resolution to this.
Well, that's good to hear. Tell me what it is.
Well,
that's just thievery. You know that? 30%? That's just thievery. 30%.
I know, Your Honor. I didn't create the loan. I understand. I understand.
You gotta be careful what kind of interest rates you're getting when you get something, ma'am. Right?
I wish I was a little more educated on things when I was in my 20s.
All right, tell me what your resolution is here.
Your Honor, we agreed to set aside the May 5th default judgment and enter into a consent judgment with a payment term of $80 a month beginning July 10th of this year and then the 10th of each month thereafter. So long as Ms. Bryan makes the payments, plaintiff shall not institute any type of garnishment relating to wages or a bank account, financial institution. They do reserve the right to
Lock in with deals on all your game day.
issue a garnishment relating to the state tax refund. Obviously, if Ms. Bryan defaults and we don't hear from her and we file the appropriate paperwork, then, all bets are off and they can do anything legally they can to collect the outstanding balance.
So the default judgment would be set aside. Consent judgment, 80 per month, beginning July 10th. What's the total amount of the consent judgment?
Total amount, $5,617.78. Yeah, so it's the same amount as the default.
Ma'am, if you pay $80 a month, you're gonna be paying this, I think, I don't have a calculator here, I'd have to figure it out, but 30% just on the 5,600 would be somewhere in the neighborhood of about $1,680 a year just in interest. If I was you, I'd figure out a way to pay this off. I don't care
Your
if you
Honor,
go
I was
ahead.
going to request if we could put within the agreements that I was given a lump sum payment of $4,213.33 that I could pay to settle. I live paycheck to paycheck like every other American, but if I do somehow come across that amount of money and I could pay it off, is there a way we could write in there that would be a secured sum that I could pay? I do plan to stay in good faith and pay my $80 a month. And if I do come across any extra money, I plan to pay on the sum as well.
So he's offering you the opportunity to pay $42,1333 in full and complete settlement of this case. Is that what you're telling me?
Correct, Your Honor.
Is that true, Mr. Johnson?
Yes, we did discuss that figure in the breakout room, and I do have to state, Your Honor, that post-judgment, that egregious interest rate from the original loan is not going to be the rate of the judgment.
You're right. You're right. You're right. But still, the point is that you can get rid of this for 4,200, but I think what you're also telling me is you can't do this, right? You can't pay that now?
No, I really wish I could, but I live, I'm a college student, a teacher, and a mom. I live paycheck to paycheck, unfortunately. And no, that's no excuse for my financial obligation, but.
Is there something you could put in the judgment that if defendant pays 421333 on or before, that she'll be credited payments? I don't know.
I don't know. I mean, if she comes back in 6 months and has a lump sum, obviously the number would change because she's been making payments. So that 42 would go down. I can state on the record and put something in there that so long as the payments are current, you know, obviously the plaintiff will entertain a lump sum settlement of.
Well, but you're just saying a lump sum settlement offer.
Yeah.
That doesn't mean anything. That's not even worth the paper it's written on.
I mean, that's the figure now, you know, I can put that in there, that's I mean, that number will not, I mean, they'll always accept that.
No, I get it. Let's see here. So, ma'am, I just want you to understand, I don't know what exactly the statutory rate is right now, but that's what this will accumulate interest on, so I did misspeak. Post-judgment, you're not gonna pay anywhere near 30, okay? But it would still behoove you to get this paid off sooner rather than later. Do you want to do this, ma'am, or do you want to talk to him further? He's saying 80 a month starting July 10th. I can't get any more involved than I already have. If you want to take this.
Yes, Your Honor, that was my proposed monthly amount. And it is the same monthly amount that when I called back to speak with them and offer more, even though it creates serious financial strain on me. I really want to do good faith and get this cleared up.
Sadly,
I was the one to suggest the $80 a month. I just wanted to protect myself with the lump sum payment and lock in with that 4,000 with the 80 taking away from it. Because if I do, like I said, if I do end up finding any extra money, I plan to take care of my financial responsibility here.
I understand. I mean, I can't do anything more than I already have. So do you want him to prepare a order that sets aside the default judgment, then enters into a consent judgment with you for that sum, 56,1778, with the understanding you pay at the rate of 80 per month beginning July the 10th, and the further understanding that so long as you do that, they're not going to garnish wages. You said bank accounts too, right, counsel?
Correct, Your Honor.
So they won't garnish wages or bank accounts so long as you make those payments timely. Do you understand that?
Yes, sir.
Do you agree to those terms?
Yes, Your Honor.
All right. Okay. Anything else, Mr. Johnson? And does he have your permission to sign your name to that proposed consent judgment, ma'am?
Can we just update it to that if we have a lump sum, we can pay the 4,000 or whatever's been paid up till that date?
Can you do something with that? Other than just leave it wide open? You might not be at that firm next time, or you might have somebody else different, or somebody else might be working on that, right? I think that's our concern.
I'll put in the lump sum, the 75%. I'll say that's good, you know. I mean, I'll put it in the order that I guess that lump sum is available for Miss Bryan. It will be in writing and it will be in the consent
Yeah,
judgment.
but what if she pays $400 by the time she can do that?
That's what I'm saying. Like, I don't know. It's good now, but the number's only going to go down. I can say confidently that, you know, 75% of the balance, whatever it is at whatever time, would be acceptable in a lump sum.
Okay? So he'll give you credit. You pay 75% in the future, but there is going to be statutory interest added on there, which is a small sum. It's not anywhere near 30. It's not anywhere near 10. Okay? Is that agreeable to you?
Sounds good, Your Honor. Thank you so much.
All right. So you're going to word it though that whatever the balance is at any given time. I just want to check. I'm not trying to corner you here. Whatever balance is owed at any given time, she can resolve the entire judgment and get a satisfaction of judgment if she pays whatever 75% is of the balance.
Correct, Your Honor. Yeah, as long as she has not defaulted on the 80 a month. Yes.
So
correct.
you have to pay the 80 a month, and remember, that's only going to go down a little bit. But you get what I'm saying, ma'am, that if you pay those payments, whatever the balance is in a month, 2 months, 3 months, 4 months, 5 months, you can get 75%. You can pay
Yes, sir.
You can get that reduced to 75% of the balance, and then that would satisfy the judgment.
So I hope to pay down as much as I can, and then when I can find some extra money, then I will pay down whatever's left of that 75%
And you'll win the
balance to
lottery.
get
Who
this off.
knows, right? You might win the lottery.
That would be
I'm just kidding. You're
After
very
I win.
pleasant young lady. Good luck to you, ma'am. So he's going to sign your name to that. Does he have your permission to do that?
Yes, Your Honor.
All right. Have a great day. Good luck to you. Thank you, counsel.
Oh, thank you, Your Honor.
Thank
Good
you
seeing
so much.
You're going to submit that order real quick to me, right?
I got it on my screen, Your Honor. I'll get it to you in the
Thank
next
you.
5.
Thank you.
All right. All right.
Judge,
I
that-
appreciate your time, Your
What's that, Jen?
the Pioneer case, there is a consent dismissal in your your box. So
Perfect.
that they did send that in already.
Am I done?
You're done.
I don't feel like this went too smoothly today. You know that?
Well, I mean,
I get it. All right. Well.
Honor.
call the case of the state of Michigan versus Tony Mosby, case number 23-00538.
Evening, what's for the people?
Want to turn
Allison Muller here on behalf of Tony Mosby. Mr. Mosby, can you please state your name?
Yes, my name is Tony Mosby.
Thank you. We're supposed to be here for sentencing today, but it appears that Mr. Mosby was arraigned before the magistrate on May 19th, told the county probation for substance abuse, and then he failed to do it, and also failed to appear at community practice test. And here we are now. Mr. Mosby haven't done anything that he was supposed to.
Hello?
Judge, you're breaking out and coming in and out. I don't know if anyone else is having issues.
Yes, because I'm having issue. I didn't hear nothing.
It's the background from Mr. Mosby's device, Your Honor,
Right.
or Mosby's device. I've muted
Right.
him.
Mr. Mosby has been muted so that maybe you can all hear me. Mr. Mosby was supposed to be here for sentencing today. Do not unmute yourself, sir. Mr. Mosby was supposed to be here for sentencing today, but he did not contact the probation department to complete his substance abuse evaluation, or he did not drug test like he was supposed to go and drug test. So he hasn't done anything that he was supposed to do. It looks like he did get the sober link, but he has not been drug testing.
Yes, Your Honor. I talked with I talked with Mr. Mosby about everything in the report and everything you just went over just now. I will say that when I contacted him, he did seem very surprised that I think when he was in custody and being arraigned, there was a lot of information. When I reminded him, hey, you were supposed to have reached out to probation, he did seem genuinely surprised. I gave him probation's number and instructed him to call them today. I said they'd probably be in court this morning, but call them as soon as we get off the record. He will do that. He has the number for probation now. I know he's kind of fallen off this case. He was dealing with a case in Detroit and was in the Salvation Army Center for 6 months. I believe he was brought directly from there to here. I think since he was arraigned in custody at the Washtenaw County Jail, he hasn't had any issues on his sober link. We did go over the fact that he had missed both of those drug tests. And he understands that he was supposed to be testing. I was trying to go back and look, and I might be missing something, but the original crime did not involve any substances. It was only alcohol. I don't know if he's had any issues since that offense on his bond or probation with substances. If he hasn't, I would ask if the court would be willing to allow him to remain on the sober link but remove drug testing. Mr. Mosby, if the court will give him a chance, will contact probation today, and I know he'll get back on track with this case.
Ms. Woods?
Judge, as far as the testing goes, I would leave that up to the court's discretion. As far as the drug testing goes, I believe he should stay on the sober link. It looks like he had a prior high BAC, so we do have concerns for the alcohol use.
So he was in inpatient treatment at Salvation Army for what?
For which underlying offense?
No, for what substances?
Oh, Your Honor, that I don't know. I don't know what that was ordered for or what in connection with.
Mr. Mosby, what were you in treatment for, sir?
Hello, yes, Mr. Mosby, alcohol. And I did since all of this been going on, this is what I've been going through.
You did 4 years of what, sir?
drug me with alcohol, mostly the treatment of me drinking. So I did like 6 months, and then I did another 6 months. And what is that place? This is right out of it. It's called like a healthy living place because I have no arrangement of my living.
All right, thank you.
So I had,
Good.
yes, I
Thank
had,
you. Thank you, sir.
okay.
All right. I'm going to continue the testing in this case for both. All right, I'm going to schedule for him to come back here on July 22nd, 2025 at 10. He needs to continue with his testing, and he needs to have that substance abuse evaluation done. And he needs to return here with all that stuff done. If not, then I guess I have to put him in custody to get it done.
Thank you, Your Honor. So Mr. Mosby, call probation and call me if you have any questions about everything you need to complete, okay?
You muted, Mr. Mosby. Do you have the phone number for the probation department, sir?
Yes, I talked to her earlier this morning.
Built for your casework.
Okay, good. Thank you. So make sure you follow through with that and get it done this time. I don't want to have to put you in jail, okay?
Okay, this has been going on for like 4 years, and I don't even understand. I've been dealing with Detroit. I've been dealing with y'all, and I just want to finish.
Mr. Mosby, what you need to understand, sir, is that you've been drinking and driving, and therefore you're going to deal with all the courts until they're satisfied that you have
I
your
know, but it's
I'm
4 years
still
ago.
talking. I'm still talking. Please do not interrupt me, sir.
Okay, I'm sorry. I'm sorry.
So you need to continue to do what we're ordering you to do until we are satisfied. Do you
Okay.
understand?
Yes, and I will make sure that you be satisfied.
All right. Thank you, Mr. Mosby. All right.
Okay.
Take care. Bye-bye.
Bye-bye.
Roll call the matter of Ypsilanti Township versus Joyce Fitch, case number 2014-00068.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Joyce Fitch. Ms. Fitch, could you please unmute and state your name? Or could you have them unmute you, please? Thank you.
Joyce Fitch.
Thank you. So on February 19th, 2025, I released Ms. Fitch to home confinement tether with the sober link. Further, get a dual diagnosis assessment, inpatient treatment, sign a release of information, contact the probation, get a sponsor, and she can only leave for appointments and treatment. I received on March. In March, I received a notice that she had missed tests. On March 9th, she had blew a .120. She missed test again. On March 9th, she blew a 1.121. She missed test again. All of March 10th, she missed tests. On March 17th, she blew a .052. There are so many violations. It's actually remarkable. So then a bench warrant was issued on March 13th. but she continued to test and she was continuing to blow. On March 18th, she blew a 0.094, 0.091, 0.090 down to a 0.073, and then she never really got to a baseline of 0 again. And then her Serverlink was terminated on March 21st because she was in warrant status. She apparently got picked up, was arraigned before the magistrate on June 12th, at which time she then started talking about how she was supposed to get a bed for home and new vision, which she had been supposedly doing that for 3 months already. So we're here today on a violation of probation. Does your client want to have a hearing or admit to the violations? Ma'am, you're entitled to have a hearing on these violations if you so choose, or you could admit to the violations. Either way, I want to be very clear. I don't plan to let Ms. Fitch out. Ms. Fitch needs to go to in an inpatient treatment from the gym. You're muted.
Sorry about that. I understand, Your Honor. No, Ms. Fitch does not want to contest any of the violations. There might be, Ms. Fitch might want to provide, I guess, a partial explanation for some of it, but she will admit there might be a memory issue. When we talked about the specifically the first alcohol positive, she said she thinks it's likely she drank. She doesn't have clear memory of that time in March of doing so, but she doesn't contest the result.
Ms. Fitch, please raise your right hand to be sworn. Do you swear affirm that the testimony that you're about to provide will be the truth, the whole truth, and nothing but the truth?
Check this out. We're generating the doors with Firefly. Oh, that's sick. Give me some ideas.
I do. Thank you. You may lower your hand now. Is it true that, well, let's start with February 28th. You missed tests on February 28th and March 3rd between 9 p.m. and 12 a.m.? Yes. Is it true that on March 9th you blew a 0.120 at 10:52 p.m. and then basically you didn't test again until 11:56 p.m. You're supposed to test every 15 minutes? I do. And then when you did test at 11:56, you blew a 0.121, so your numbers went up? Is that true, ma'am? Yeah, I do. And then I guess you continued testing because the time flipped over to March 10th. No, you failed to continue to test. And then on March 17th, you blew a 0.052. That's true. And then and I'm going to skip some of these, but on March 18th, you were blowing numbers as well, 0.094 down to a 0.073. Is that correct? Yes. I find that there's a knowing and willing admission to the violations. Are you satisfied? This is Mr. Barnett's case.
Yes, Your Honor. Thank you.
Defense is satisfied as well, Your Honor.
Okay. So, Ms. Fitch, you obviously have an issue, but you've had this for a long, long time. Yes. Do you want to work on it, Ms. Fitch?
Yes, I do. I have so much illness and sickness. I go through a lot. I'm not trying to cry, but during this time, I've been back in the hospital, had to have surgery, had to have my testing taken out from when I had the cancer. And that was in March. And I've been back and forth to the hospital. I did my community service. And no, I didn't just call this home and new bed. I just didn't call them when I just got arrested. I had been called them. And then I had to go in the hospital. When I had to go in the hospital, then I had lost my telephone. I had to get my phone back. And they were trying to call me. But before I even came here this time, I had already talked to them. They had told me they was going to call me this week, between Tuesday and Wednesday. So I got in touch with them yesterday. They said, oh, we've been trying to call, but like I said, I had been in the hospital and I lost my phone. And I got my phone back. I was able to get the same phone number. But I've been called the rehab place, and they had got me a place, a room, but I ended up in the hospital. So Tuesday, yesterday, they called me and said, man, we got the bed for you. It's Tuesday on the 24th of this month. So, I did my community service. I'm back in and out of the hospital. I'm really going through a lot. I'm going through a lot in here. This Sunday just passed, I was in here. My sugar, 800. Every day I'm in here, my sugar between 600 and 800 because they don't have the insulin for me here. I have to have special insulin because of the cancer that I had. So this insulin here would never work for me. And they told me Steve was going to bring the insulin up here for my house because I have special insulin. They said, oh, you can't bring no insulin from home here. You just have to take what we give you. At home, I take 1 shot a day. Here, I take about 10 shots a day. Every 5 minutes, they want to give me a shot, and it's never going to work. They give me a shot, sugar 500. They give me a shot, sugar 600. Sunday, 800. Now, they say, man, we don't know what to do with your sugar because we cannot get your medicine. I said, well, can I bring the medicine from my house? Because I have special insulin. Oh, no, they bring the medicine here. We're going to put it in your property. We're just trying to keep you alive. I just want the right medicine. All these shots is going to make me have a kidney failure. I'm going to be worse than what I am. I want to go to rehab. I've been calling the people. I got the bed.
Jump in my new EV with me. I found it on cars.com.
And I'm ready to go. But I don't want to die before I get there. I can't get 800 sugar every day. I'm so nervous in this place. Every time I see the nurse, I'll be about to faint.
Your Honor, Ms. Fitch, she told me today that a bed is available at Home and New Vision on June 24th. She did give me a contact number. I haven't been able to reach them yet to confirm this. But what Ms. Fitch and I wanted to ask if we're able to confirm that that bed is really available on June 24th is that she be given one last chance to be released on home confinement GPS and report directly to Home of New Vision on June 24th.
Anything from you on this, Mr. Barnett?
I don't think that's appropriate given the circumstances, Your Honor. I think she needs to go direct from the jail.
And Your Honor, I understand where Mr. Barnett's coming from. I am concerned. I do think her diabetes issue is serious. She's been calling me since she was in the jail on it. I reached out to medical at the jail. I haven't heard back. But I know she's been concerned. Her mother's been calling me as well, very concerned about her diabetes and how she's reacting in the jail.
You think drinking alcohol while you have diabetes at that level is appropriate? Neither one of them.
No, I have had a drink, but I'm not drinking like I'm just drinking. But my sugar, these people can't control my sugar. Before I came here this morning, my sugar's almost 600. Right now, 600. I just took a shot. The shot's not working. I'm gonna be in a coma. I want to go to rehab. I'm going to go. I just want to go. I can take my medicine.
This since February, Ms. Fitch. I'm not doing that. What
Okay,
I'm
what I'm gonna do here with the diabetes? They can't get it down low. What am I gonna do? They're going to come and go in the hospital. I'm not making.
I've muted her. I heard her. I'm very clear on what she said. I'm also very clear that she says she's not drinking. 0.09 is certainly drinking. What I'm gonna do is I'm gonna pass this. Can you call medical again? So that I can get some idea of what's going on with her insulin. If she needs special insulin, then I think they need to take her to the doctor so they can get her that. So can you
medical now.
up there? I'm gonna pass this. All right. Back on the record in the matter of Joyce Fitch, we have had an opportunity to discuss this. And it appears that the medical information that was received does not quite comport with what Ms. Fitch is indicating. And so, which is what the court's concern was. There were some numbers that were moderately high, but nowhere near the numbers that Ms. Fitch is.
Sunday, my sugar was, the meter read high. The lady said my sugar was 700 to 800. I'm not lying about that.
Ms. Fitch, if you interrupt me again, I'm gonna hold you in contempt of court. So, the court will continue to monitor Ms. Fitch as often as the court can. Ms. Mueller, I have asked you to speak with Inmate Services and Home and New Vision to try to get her into the bed over there as quickly as possible. So if the bed is available on the 24th, she should be released directly into the bed at that time. She will be released on a GPS tether, if she is released. Ma'am, if you leave the treatment, then I'm just gonna put you in jail for the rest of the term of your.
Never do that.
I'm sorry?
I said I would never do that.
Okay. We're scheduled for her to come back here on July 1st, 2025 at 10. Hopefully she's in treatment at that time. But bond is continued.
So they'll take me from here to the rehab?
Yes, they will, ma'am.
Okay, if I'll be in the hospital dead.
Mhm.
I'll give it 3 days I've been in the hospital. Thank you. You fit?
Yes, ma'am.
I give
Court will call the case of the state of Michigan versus Lawrence Buckner, case number 25S00102.
Tiffany Woods for the people.
Bug Center Docket leave on behalf of Mr. Buckner. Mr. Buckner, can you state your name, sir? Mr. Buckner, could you state your name, sir?
Lawrence Buckner.
And could you turn on your video, please?
Built for your casework, grounded in the record.
All right, we're here for sentencing today.
Yes, Your Honor, I have reviewed the report and recommendation with Mr. Buckner. Your Honor, I don't believe we don't have any factual modifications to the report. I would like to provide them elocution. Shouldn't ask the court not to accept the recommendation.
Thank you. Ms. Woods?
One moment, Judge, I'm pulling up my notes right now. My computer is just a little slow.
Mr. Buckner, are you driving, sir?
No, ma'am. I'm not driving.
Judge, I've also had an opportunity to review the PSIR recommendation, and I'd ask the court to follow the recommendation within that report. Thank you.
Mr. Buckner, why do I hear your blinker on?
That's my hazard lights.
Your what?
That's my hazard lights. Those are my hazard lights.
Mr. Lebo, what would you like to say on behalf of your client, please?
First, I want to note that when I discussed this with Mr. Buckner yesterday, he told me that he understands that when he got upset, when he felt provoked by the officer, he should have kept his mouth shut and he shouldn't have made any kind of threatening statement, even if he felt disrespected. He did ask me to let the court know that he was at a gas station getting his tire fixed during the interview. He tells me that he was not driving. He also wants me to let the court know that he will comply with any probationary sentence issued by the court. He did state to the probation he doesn't feel he would benefit from probation, but he did tell me when we spoke that he will comply fully with any probation conditions imposed by the court. So we would ask the court to consider imposing a fines and cost sentence or a period of probation rather than filing the recommendation for 30 days in jail.
Did he do a class? I was a little confused because it said in there he did the class. Did you do a class, Mr. Buckner?
No, I've been just going to my regular therapist. But what the Mr. Lebo is saying, what he's talking about is the PSI and what I stated assertively. And I think you would be proud of me, Miss Rushing, because I didn't raise my voice, I didn't cuss, and none of that crazy stuff I normally do. And it was 2 incidents that the probation reviewer person said to me, and I really don't want my words misconstrued. I don't want them taken out of context. He said, when he got first thing, he said, talk about the apology. And I told the probation officer, I said, if you was offended by a person, would it be more genuine for the person who offended you to apologize or for you to get a third party? Case in point, your sister stole some money from you and you feel she owes you an apology. You want to forgive her. You want to move forward in life, but she doesn't come forth. Your mother or another relative comes. Anybody that's a natural human will see that that is non-genuine at all. The officer never felt anything wrong about the way he treated me until you pointed it out. So if you would have never pointed it out, there would have never been an attempt of an apology or anything. I'm a regular human being. I try to live on regular life principles. Right is right, wrong is wrong. Like I told the probation officer, I never, not one time, did not take accountability for any of my actions. I was trying to be very clear, direct, and assertive as possible in giving my reason as to why we here today. Even during the court proceedings, you reprimanded the officer, but the bad part about it is the officer don't get no charge. I get a charge. And like I told him, life is not fair, but I will accept anything. Even though in my heart, I may not agree with it, I'm still going to accept and comply. That's what I told the probation officer. And by me saying that, that is not being defiant to the courts. It's not being defiant to anybody of authority. I just simply say, hey, I'm going to do whatever I got to do to stay free, even though I don't agree with it. That's exactly what that means. So for my words to be taken out of context, yes, I'm very, I feel very disrespected. I feel like it's a plot against me just to throw me in jail. 30 days in jail ain't going to do nothing. It's what will it benefit to remove me from my family for a phone call? What warrants that? I really would like for you, because the whole meeting was videotaped. I really would like for you to watch it. Because if you watch it, you will see that I was assertive as well as respectful. I didn't disrespect nobody. I was very clear about everything that transpired during the situation. Do I feel messed up? Yes, because the officer that I made the statement towards
is the same officer that's been arresting me since I was a teenager. So, it is my belief, and notice I said it is my belief that the moment the phone call came in, that officer didn't care about the threatening of the other officer. He's like, I finally got Lawrence Buckner, and I'm gonna go push this all the way up. And like I said, that's my belief. You know, I just sat in jail for 30 some days for something that I didn't do. And like, it's a difference between actually committing a crime, getting caught red-handed versus somebody, constantly going to jail. And this was all one big thing because you have been my judge, named there for every case. I have lost my dogs. I've lost my business. I have lost my entire livelihood because of a woman telling a white lie, to where now I got to get transcripts from the courts so I can file a lawsuit because I got put in jail for being black, being at the wrong place at the wrong time. And these officers are the same officers who have been arresting me since I was 15 years old, and then want to get in front of you and act like they don't know who I am when the officer admitted in court, yeah, I dealt with Mr. Buckner in the past. Because you dealt with me in the past, that's why as soon as I called, you was instantly, oh, he a liar. I don't care nothing you got to say. And then when I respond out of feelings, out of hurt, out of embarrassment, now I get a charge. Now I want to be put in jail for 30 days. So what does it really warrant? Like, I just lost my whole livelihood. They took all my dogs because of this. Everything.
Mr. Buckner, you're yelling again.
Oh, I'm sorry. I'm my bad. My bad. I apologize. Like, nobody's taking into account of that. Nobody's saying, hey, for every action, there's an equal and opposite reaction. Okay. I didn't just get on the phone threatening nobody. I tried to be respectful. I tried to follow the chain of authority to report abuse of authority to his colleague. And what do I get? I get mistreated. I get disrespected. I didn't deserve that. And all he gets to do is get a reprimand and go about his life. He don't care about no apology. He don't. He didn't care until you pointed it out. And that's just like if you raising children and you say, go apologize to such and such. If you have to tell that child to do that over and over and over again, that child will never learn to give a genuine apology or be accountable on his own. I was greatly disrespected, me and my family. For what? And jail? And then the prosecutor want to just send me to jail? She don't even know my life. She don't know what I've been through. Everything is just jail, jail, jail. Jail is not always the answer. Jail is not the answer. How is jail the answer? Can't nobody in this courtroom explain why jail is the answer. If I was so much of a threat and anti-government, I'd be blowing up buildings. You see me blowing up buildings? You see me starting stuff? I'm not doing nothing. The same stuff I've been doing when I came home from prison in 2020. And every time I tell the courts on record, on YouTube, every time I tell the courts that I have been maliciously persecuted by Washtenaw County sheriffs for not cooperating when I got shot, nobody believes me. Nobody cares. But all these magical cases come up on me. Places that shootouts happen and I wasn't even there. My GPS proves it, but I'm still in jail. Like, my mental is broke down. I have no more faith in the justice system. I am done. My life is in the last 6 months has went to crap. Okay, over a white lie. And in 2025, you would think that you could drive anywhere around the United States. But no, that ain't the case. That I was instantly stigmatized as a drug dealer, pulling up and then passing out guns. Man, my life is ruined. I worked so hard to build my dog community up. I took my dogs to the old folks home. So many people was affected by this. I took my dogs to schools. I took my dogs to help children. And now I'm so much of a threat to society to where I have to be remanded to Washtenaw County or suggested I be remanded for Washtenaw County with nobody not even doing no type of investigation on my life. Like, I'm actually an asset to my community. I'm not a liability to my community. You put people in jail that's liability, that's not assets, that don't benefit, that don't bring nothing, that don't have no self-worth or not knowledge of their self-worth. People who have self-worth, people who making a constant effort, especially from the degrees of changes that I've made from my past. I'm doing remarkable, you know, and still in yet, like I still, for the life of me, cannot understand as to why I'm sitting in front of you. I swear I don't. You know, I try to sit about it every day. These are the same officers that pull me over every single day, every other week, harass me, and then get into court and act like nobody harassed me. Why would I call the police? I called the police on the police. So that means something had to happen to me. Something is constantly happening to me, constantly pulling me over, constantly sitting in front of my house, just harassing me, constantly coming to my house every day. Come on, come to court. Tell us she shot. We need you to testify. No, no, no. And then as soon as I keep telling them no, I get all these magical cases. Like, why won't they just leave me alone? Nobody will listen to me. Nobody. I've been in jail for over almost 2 months for nothing. I can see if I actually did them crimes. So my whole religion, my spirituality is crushed. I don't know what to believe no more. I was a very religious person, a very spiritual person, but life done beat me down. It done beat me down. And everything I think about is what happened to my ancestors. It's relevant to me because I went to jail for being black. So yes, my mindset is different. My mindset is very different. I don't know. I don't trust Europeans because a European just tried to take away my life. A European came to court and lied on me when all these cameras proved I didn't do nothing. And I sat in jail. I was tortured. I was not allowed to practice my religion. None of this. I just missed my aunt's funeral. My aunt just died. She was the only person to ever write me in prison after my mama died. And I couldn't go to my aunt's funeral because of a tether, a GPS tether that Judge Simpson ordered to be taken off. When Judge Simpson ordered to be taken off the tether, they still left me on the tether. I couldn't even go to my aunt's funeral. I couldn't even do that, but nobody's talking about that. I had a court order to take it off, and I couldn't even go pay my respects. This woman, she didn't have much. She sent me money. She made sure I had a letter every week. Every week. She'll tell me I love you, even though it was just the words. But nobody's looking at that. Just send Mr. Buckner to jail. Send him to jail. Jail ain't the answer.
Thank you, Mr. Buckner. So back to what I asked initially, did Mr. Buckner ever take a course? Because it says in the report on page 2, the defendant was instructed to complete an anger management course before sentencing. The defendant completed this course, but it appeared to have no impact. I don't remember asking him about taking a class. Is all of that incorrect in the report?
Your Honor.
It's incorrect, man. It's incorrect.
All right, Mr. Buckner. Mr. Buckner, thank you.
Please, I need to say this. The officers have been harassing me, and I really want to just make this on note that this is also evidence of what they're doing to me. And I don't know if something gonna happen to me soon, but I want this on record. You know, I don't trust the police. I think they're trying to kill me. I think that one of the police officers involved in my shooting, nobody will listen to me. And I need some help. I need some help. I fear for my life. Every day I fear for my life. Nobody will help me. Nobody will help me. And I want this on video in case something happened to me.
Thank you, Mr. Buckner.
No, I don't.
Mr. Pappenhagen.
That's my apologies. I mistaken. That was a mental error on my end.
I'm striking all of that from the report. Anything from anyone else before I proceed with sentencing?
Nothing from the people, Judge.
No, Your Honor.
The defendant is to complete the ABR anger management course and pay fines and court costs in this case for a total of $275. I'm gonna see him back here in 90 days on September 23rd, 2025 at 10 o'clock a.m. 180 days in the Washtenaw County Jail, credit for 11 days. The balance is suspended. So he doesn't have to do any additional jail time. If he pays his fines and costs, completes the class, and tells me what he learns from the class.
Thank you, Your Honor.
I want to say I heard every word that Mr. Buckner said. I truly believe that he is concerned for his safety. And bottom line, though, is 2 wrongs don't make a right, and that's why we're here. So I'll see him back here in September.
And that was the 23rd, Your Honor.
Correct, at 10.
Thank you.
What will call the case of the state of Michigan versus Abdel Mohsen Osman, case number 22S00833.
Tiffany Woods for the people.
David I. Goldstein appearing on behalf of the defendant.
Ms. Osman, get them to unmute you, please. Please state your name, Mr. Osman.
Osman.
All right, so we are here today for several things on Ms. Osman's case. One is for the court to finally issue a ruling regarding the hearing that we began, and the court reviewed video thereafter way back in January.
No harsh side effects like gas, bloating, cramp.
On this particular case, and then Mr. Osman appeared on February 6th, but it was after Mr. Goldstein had already left. And then Mr. Osman decided to no-show on March 13th of 2025. The court then issued a bench warrant for which he was arraigned in front of the magistrate on June 10th, 2025. In the interim time period, Mr. Osman had also absconded from supervision through community corrections. And was not testing.
Yep, that's all. Thank you so much.
He's not reporting for download, so that we would know what was happening. So, where would you like to start, Mr. Goldstein?
By saying goodbye. Your Honor, I have had no contact with Mr. Osman since January, since the hearing we had in January. I was only aware that he had been arrested on the warrant and had court today because the public defender's office was kind enough to let me know that. I did read the report that was submitted. I'm assuming the court has seen it also. And I have not had an opportunity to discuss with him, but based upon that report, it looks like he's not doing what he needs to do.
Well, I think maybe you should talk to him because at this point, I plan to follow the recommendation. It just seems like we just get this case done and over with. So,
Your Honor, I frankly, I suspected even had I spoken to him, that you were probably going to do that, given what the report says. I don't know that, I mean, I can take some time. If we can adjourn it a week, I can take some time to talk to him, but I don't know what good it's going to do.
well, I was just going to put you in a breakout room with them right now, so you can.
Okay, that's fine. That's fine. That's fine.
Thank you. That's what we're going to do. We're going to pass this and put you in a breakout room. The court will call the case of the State of Michigan versus Ronald Larry, case number 24S00212.
Tiffany Woods for the people.
Assistant Public Defender Davia Lebo for Mr. Larry. Mr. Larry, could you state your name, sir?
Ronald Larry.
Thank you. All right, we're here today on the defendant's motion to quash the search warrant. I do have the motion as well as the response from the people.
Yes, Your Honor, there are a few points I do just want to briefly highlight.
All right, you may proceed.
First, Your Honor, the state's reply brief reiterates that Deputy Burton claimed to have seen Mr. Larry's car parked for an hour. We know both from Deputy Burton's later statement of the video as well as statement from the court that he didn't see Mr. Larry's car parked for an hour because it wasn't parked for an hour. It was parked for 25 to 35 minutes. I also want to highlight that the passenger who was actually seen to have a gun was never asked to step out of the car. The only person asked to step out of the car was Mr. Larry, who at no point had a weapon and no point was seen to have a weapon. And most importantly, the video clearly shows that Mr. Larry was not irate when he was approached by Deputy Burton, and he was not slurring his speech. There's no other place those statements could have come from other than it simply being put in there. It's simply being, because the video clearly shows there was no slurred speech and there was no irate behavior. So based on those, I would argue that the search warrant should be quashed, Your Honor.
Well, before I go to the prosecutor, I want to ask you about her last page 6 argument, I believe it is, which is that even if those statements were false, that he had bloodshot eyes, that his speech was slurred, is it not true that probable cause for the search warrant exists with the mere facts that the defendant was observed in the driver's seat of a vehicle that was running, and that the vehicle was parked offset at a gas station at the pump, and that the passenger had admitted that they both were drinking and the defendant was driving, and that the defendant smelled of alcohol and refused the SFSTs and the PBT?
Your Honor, I have two responses to that. Firstly, I don't believe that, as discussed in the motion, I don't believe the police had reasonable suspicion to execute the traffic stop in the first place. And the traffic stop occurred when the other two deputies parked behind Mr. Larry's vehicle with their emergency lights on. Secondly, I do believe that they didn't have sufficient that the false materials necessary to find a probable cause, because slurred speech is a very specific indicator of someone being intoxicated. The rest are not specific to being intoxicated. Parking offset at a gas station, that's an ordinary activity people do sometimes after getting gas. The passenger admitting that both parties were drinking, that again is a normal thing people do. That does not by itself, without some further evidence, show that there's any reason to believe that someone is in fact intoxicated. Regarding to Mr. Laird smelling like alcohol, what I would say is that I don't know that we should credit Deputy Burton's observation that he smelled like alcohol, given the false statements regarding the slurred speech and the irate behavior.
Ms. Woods?
Yes, Judge. I believe there was reasonable suspicion. This was not a traffic stop. I believe that this was akin to a Terry stop because the vehicle was stopped. It was stopped in a manner that it wasn't legally parked in a parking spot. It was, I had given some pictures as to how the car was parked.
in a manner that it wasn't even able to get gas from the pumps. Now the deputy believed that it had been parked for about an hour. That's his belief based on his training and experience and from when he saw the vehicle.
He went into the space and the clerk said it was 35 minutes.
And he wasn't, I don't believe he was sure either, because he said it was 25 to 35 minutes. So, and the deputy didn't lie about that. He said, you know, he put it in his report. He didn't try to hide it. He said he believed it had been about an hour. The clerk said he believed it had been about 25 to 35 minutes. There's two deputies on scene that say he smelled of alcohol, that his eyes, again, there were issues with the way his eyes looked, and also that he was slurring his speech.
I watched the video. I didn't see bloodshot eyes.
I believe that it was difficult to see the bloodshot eyes in that video as well, but I believe that you can see that his eyes are watery and glassy. As far as the irate and argumentative judge, I watched the whole entire video. It's about 2.5 hours long. He was argumentative and angry throughout most of that video. When the officer was sitting in the vehicle, the way on their drive to the hospital, he was acting that way at the hospital, also towards hospital staff. So I don't believe that any of those remarks put in the police report were untrue as to what defense counsel is arguing, that basically everything in the police report's not true, and I don't believe that at all. So I believe there was probable cause to do this investigation and that there was probable cause for the search warrant.
So I think that what you need to address is Mr. Lebo's responses to my questions to him. You know, if I accept that there was no bloodshot eyes, which I didn't see bloodshot eyes, and honestly, this is one of the most clearest pictures of someone's face on screen that I think I've ever had the opportunity to see up close. But that's not really the issue of whether or not those things are false. Even if they're false, the next step in that process is, if those statements are false, what evidence are we left with what evidence is left? And if there is evidence left, whether that arises to a probable cause level. And that's the piece that I asked Mr. Lebo about. And that's the piece that I think you still need to address in terms of his responses to that argument, that even if I accept that his eyes were not bloodshot, and I believe that that statement may not have been true, or that his speech was slurred. I only heard slurred speech at one point in the discussion, and the rest of the time, Mr. Larry was very clear. I would agree more with the prosecution that he was unhappy that he was being stopped at that time, whether we call it a Terry stop or a traffic stop. He was very unhappy with the fact that he was being stopped and did not appreciate what was going on and felt as though he had done nothing wrong. I did watch the video. I did see the pictures of both his eyes that were provided to me by the defense, as well as I saw.
Built for your case.
The pictures that were provided by you, Ms. Woods, with the car askew, and it's clear in the video that the car is sitting askew. in a very odd space at the gas station. So the fact that the police were alerted to him, there's no question as to why that happened. The issue becomes, and it really does boil down to me to those last statements by the prosecution, which is, without the statements that were placed in that report, there is still probable cause to have a search warrant. So I need for you to respond to what Mr. Lebo said. And Mr. Lebo, you might want to repeat what your responses are to that so that she can respond to them.
Yes, Your Honor. So my response was that even if that we should not credit Deputy Burton's claim to have smelled alcohol, given the other false statements in the report. And that once we take those statements out, all that's remaining is the position of the car, which is not probable cause for drunk driving. There are many innocent explanations for a car being parked in a particular position. And the fact that the passenger, after the stop was conducted, after Mr. Larry was asked to leave, was asked to step out of the vehicle, both stated that both were drinking. She never stated that Mr. Larry was intoxicated. However, we also know that there was a focus on Mr. Larry throughout the stop that was, it seems unusual, in that the passenger who had the gun was never asked to get out of the car, but Mr. Larry was. So if we exclude the fact that his speech, if we take out the slurred speech and the bloodshot eyes from the report, what we're left with are extremely subjective statements that I don't believe add up to probable cause in and of themselves. Slurred speech is a highly specific indication to drinking, as are bloodshot eyes, Your Honor.
Thank you. Ms. Woods.
Judge, and I would argue that probable cause for the search warrant would exist with the facts that the defendant was observed in the driver's seat of a vehicle that was running. In the manner that the vehicle was parked, it was offset at the gas station pump. And if we even look at whether it was parked for 25 or 35 minutes, Mr. Larry said he pumped gas and he was only there for a minute. It's common knowledge that it doesn't take 35 minutes to pump your gas. The passenger admitted that both parties were drinking and that the defendant was driving. The defendant smelled of alcohol. He did have watery and glassy eyes, and that's something that defense counsel said that he argued that could be apparent in the first part of his report or motion that he wrote. But then he said, well, he's for sure that the eyes were not bloodshot. He refused the field sobriety test. He refused the PBT. He was argumentative with the officers. And I based on all of those factors, I believe that there was probable cause for the search warrant. Thank you, Judge.
Anything further from anybody else?
Nothing from the people, Judge.
Thank you. For all the reasons that the prosecutor just placed on the record, I believe that there was probable cause, even if those other factors were not true. And I believe they weren't true, but there is still probable cause for a search warrant under these particular circumstances. You can't sit in the middle of a parking lot with a car askew for 35 minutes and not believe that someone's going to question what's going on based on the way that car was parked. And so after that, everything that came after it can be used in this case to determine whether there is probable cause for a search warrant. I find the search warrant was valid.
Thank you, Your Honor.
You need to talk to your client?
Yes, Your Honor. Well, actually, I'd be requesting an adjournment today so we can discuss what the plea options may be.
All right. Pre-trial in this matter will be adjourned to July 8th. Is that enough time?
Yes, Your Honor.
Mhm. Pre-trial is July 8th, 2025 at 9:00 a.m. Bond is continued. We'll see you then. Mr. Larry, you don't have to agree with my ruling.
I don't. It's okay though.
I understand. We'll see you back here on July 8th, sir.
I guess so.
State of Michigan versus Abdel Mahassan Osman, case number 22S00833.
Tiffany Woods for the people.
David I. Goldstein appearing on behalf of the defendant.
All right, Mr. Goldstein, you had a chance to talk to your client. Does he want to admit to the violations?
He basically disagrees with everything in that report, Your Honor. He wants a hearing.
Okie dokie. Well,
I just want to say something. There is misunderstanding here in the case.
to say anything. Stop talking.
No, I just want to say, explain something.
I said, stop talking before I hold you in contempt and give you additional time on the time that you're about to get. All right, so what I'll do is I'm going to make my ruling on the initial hearing that we already had, and I think this will resolve this issue anyway.
That's the cocaine issue, Your Honor?
Yes, absolutely.
Okay.
The cocaine issue. So I did have an opportunity to review the video in this case. And in reviewing the video, I find that there was sufficient evidence to believe that it was his cocaine based on the fact that he lied about I don't know how many things, including the fact that he was lying about how long he'd had the video. There were the car. There was paperwork in the glove compartment box that clearly contradict anything that was presented by the defense in terms of how long Mr. Osmond had had that particular car. I believe he had the car. I believe that the cocaine that was found in the car was stuffed in the place that it was stuffed in by him, and I find that he's guilty on that violation. All right.
Naomi just discovered the sweet sound of earning and saving money.
Anything else we want to have to say about that? We can move on to sentencing.
No, Your Honor.
All right. Anything from you, Ms. Woods, in terms of sentencing?
Judge, I would leave it to the court's discretion. Thank you.
All right. Now, Mr. Osmond, you may talk. You can ask them to unmute you now.
Yeah, I can talk about first about the car. I wasn't have the car as long as I say before. I don't know what paperwork you found in there, but I wasn't have the car as long as I say I have it. And for the other case that we're talking about, I wasn't in a testing program for the alcohol or any drugs. I was in a GPS tender.
Mr. Osman, the only thing that's before the court right now is the cocaine.
Okay.
The judge is not addressing anything else today other than that.
Okay, so for the cocaine, I didn't have nothing to do with the cocaine. I have nothing to do with the car before a month I get out of jail. I was in jail before I go get that car. I don't know what paperwork they found in the glove compartment. It's showing that the cars belong to me. There's nothing in the car belong to me. And I have, as I say, I don't want to go in the same situation I went before. February, I have court in front of Miss Washington. I got evicted from the house in the 30th by the court order. And that's the only reason I was seeking to find me a house. I just found a house. I don't want to lose it again. Yeah. And I just make my family together. I don't want to lose them again back. Yeah. And I have nobody working at the house beside me. So I'm the only one working to provide the family. I have 3 kids. I have a new wife. I have a lot to do. Right now, I have set of note for DTE today. I can prove it to the court right now. You know when they let you. I don't know how I'm gonna pay all those bills while I'm here in jail. And I'm not risky. I didn't show in the court because they say I have warrant for my arrest because I didn't went to test when the probation officer asked me to go to test or go home when I was looking for the house that I'm in right now, which is the address 2621 East Lawn. That's the last time that my GPS showing I was. And he gave me the permission and he called me. I tell him I'm looking for the house. I'm waiting for the owner to show me the house. He say either go home or go test right now. And I wasn't have the car to go to test. So I waited for the guy came. I pay him some money, which is so expensive for me to rent a house for $2,200 a month. And I don't have no choice. And the only reason the probation officer asked me to test because the deal I give him. I have no choice besides selling my cars with the way half than the price. I offer the probation officer to buy a car 15,000. I tell him buy it from me for 7,000 because I don't have no way to go out to the market. That when he saw that I might be drinking or doing drugs, he asked me to go test. And the time he asked me to go test, there was not enough time for me to find a ride to go to test.
I don't get out. I'm stuck. I know what I'm ready. Anything else from you, sir?
I just ask you, Honor, please, please, if you can give me personal bond so I can take care of my house. I don't want to lose my house again. I just have a house. I just got married like 2 months ago. Please.
Right. Is that it, sir?
Yes.
All right. Defendant's bond, probation is revoked. Defendant is sentenced to 180 days in the Washtenaw County Jail. Credit for 7 days served. The balance is of 102 days is to be served. We're done.
There it is. That's it for today, ladies and gentlemen. Again, if you're not a subscriber to this channel and you like the content that's on this channel, please do me a big favor and subscribe to this channel and help this channel grow. You can also follow me on Rumble. The link is on the main channel's page. So that's it for today, ladies and gentlemen. Ta-ta and ciao-ciao. I will see you tomorrow for Sovereign Citizens, which ought to be pretty funny. So that's it for today. You all have a wonderful, wonderful evening, and I will see you guys tomorrow.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to man all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your hour, standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay.